Are people being pressured into pleading guilty for their involvement in the UK riots? Well, to talk about this, I've brought back our learned friend Alan Robert Shaw from Art of Law. We'll link in the description below. And welcome back to Secrets, where we can be a little bit more relaxed, shall we say, Al, about what we say here. So none of this is intended to be legal advice or too opinionated so that it gets us into any trouble, but we'll give you some thoughts on it nonetheless. I've certainly had lots of comments, and I know you've just said that you've had the same, Al, where people are saying, to quote one of your viewers, why don't you just be honest and say that everyone's being pressured into pleading guilty for their involvement in the riots? And I don't really think that's the case, but let's talk about it. Al, you had some thoughts on this.
Well, yes. I mean, I did a recent video about sort of bail because people are saying, yes, well, people are being pressured by being told, if you plead not guilty, we will hold you, we'll remand you in custody for years and years and years until your trial. And it's, has there been any evidence that that has been happening? I mean, as far as I'm aware, there have been around 1,000 arrests so far and about 200 guilty pleas. And as we've discussed before, if people plead guilty, then matters can be dealt with very, very quickly, within a matter of mere days, because you are produced at the magistrates' court. If they think it is too serious to be dealt with in the magistrates' court, they send it to the Crown Court. Now, when people talk about two-tier justice, I think one thing that the lawyers have been commenting on is, well, yes, we have proven that you can actually do things this quickly. Because they've thrown a lot of funding at this. They've allocated 70 judges. And just to clarify, that's the judiciary themselves who have done that. Judicial listing is purely a judicial matter. The government has no say in allocating cases or anything like that, or resources. The budget is given to the system, the criminal justice system, and it's the judges themselves who allocate the work. And they've always been saying, look, there aren't enough judges, there aren't enough defence counsel, there aren't enough prosecutors. And the other thing is we don't have enough courtrooms. So yes, these cases have been fast-tracked. And, people have been quite open about that. The knock-on effect, of course, is that has just put pressure on the system generally, because, there's a finite number of courtrooms and there's a finite number of staff. So when we talk about two-tier justice, I think one thing we can talk about is two-tier resource allocation, but that's more of concern to lawyers. But I
absolutely, yeah. I just jump in there. I've had exactly that more than once, particularly with family courts, where they are struggling for resources a lot of the time. So I've been there ready for a 2-day trial or whatever, or fact finding, and the judge has just walked in and said, "Right, we've got an urgent case coming in. Everyone get out," and that was it. Everyone was there ready, and it was just kicked out because they had something else coming in. So there's just no resources, literally no resources. So it does happen.
It does. And when cases are listed, even for trial, a lot of the time they're listed as what we call floaters. First of all, you get put in a warned list. So say your trial will probably take place at some stage in this 2-week or 4-week period. But then they're often listed as floaters, which means you turn up at court and just hang around, floating around, on the off chance a courtroom becomes available. It's very rare to get what we call a fixture, where a trial is listed and yes, it will definitely start. And they intend only to do that if it's something like there are vulnerable witnesses, like child witnesses or something, who they don't want to mess around, or there's some, other witness availability issue, or there's some technology issue, they need particular video playback or something like that. But yeah, I mean, the system, as we've been complaining about for ages, is creaking at the edges. I mean, they've sold off 141 court buildings. That's not courtrooms, that's court buildings. And that doesn't include where they were renting buildings and they haven't renewed the lease. I mean, there is a tracker that shows how many courts are sitting on any one day. And I just had a quick look on Friday, and even though there are limited courts, 31% of available courts weren't being used for whatever reason, because they didn't have the judicial staff, or they didn't have the support staff, or they weren't the right number of sort of barristers available, because because of the funding issue. A lot of people now, there's a massive shortage of barristers willing to prosecute or defend crime. And interestingly, what we call RASO, and that's the R word, and it's and then it's something offending cases.
Yeah,
The
the very
special
serious kind of assault cases, if you know
Yes,
what we mean.
those sexual assault cases. What's interesting now is the CPS have lowered the threshold for people to be RASO qualified. They've basically said, so long as you've attended the course, whether you've actually done the assessment or not, we'll count you as qualified. I mean, I think that in itself is that's more of a scandal than what people are complaining about here. But yeah, I mean, back to the point, are people being pressured by being told they won't get bail? I mean, I've seen no evidence of that. And as we've said before, there is a presumption of bail in the Crown Court, well, in all courts. And to refuse bail, the prosecution have to show one or more of the following. They have to show there are substantial grounds for believing that either the person will fail to attend, will commit further offences, or will interfere with witnesses or otherwise the course of justice. And the burden is on the prosecution to do that. So, I mean, and just asking around, I mean, I haven't heard, and duty solicitors who, initially deal with these cases. And just to explain, a duty solicitor, they're just regular sort of self-employed solicitors who are just on a rota. It's not like we don't have a public defender system in this country per se. So it's just solicitors from local law firms who, they know what they're doing. They're highly qualified. And I think if there was any sort of, hint of this, they would be the first people kicking up a stink about it. And I haven't heard a whisper.
Absolutely. And there's, if I put up on screen here, there's these are just a few that, with the assistance of ChatGPT, to pull some of these sentences. I mean, this one highlighted here is that lady with the wheelie bin that people will remember from the news. So she got 20 months. William Morgan, 32 months. Ryan, 2 years, 2 months, etc. So lots and lots of harsh sentences. But you'll notice each of these, they're saying, pleaded guilty, admitted the offences, and so on. And the point here is, and the question here is, are these being pressured into pleading guilty for fear of being remanded into custody until their trial? Obviously, bearing in mind there is a limit, an overall limit for that as well. But them admitting their involvement, they will clearly, I mean, just to clear this up, they will have had advice on whether what they've done makes out the elements of the offence, therefore whether they're likely to be found guilty if they pleaded not guilty, and bearing in mind the credit, because you get a third off the sentence if you plead guilty at the earliest opportunity. So all of this would have been explained, would have been advised, and so they do have that choice. But there is still a degree there, probably, as to whether someone just pleads guilty just so that they get the discount, if they just fear being found guilty, even if they think they're not, but for their involvement. But all of these things, they're not just. I think one thing that does frustrate me is when you see in headlines that someone was either plead guilty or whatever, and sent to prison just because they were there. There's always more to it than that. It wasn't they were just walking by and then roped in. It's not quite like that, is it?
No, I mean, the thing with public order offences and, joint enterprise, and joint enterprise is a controversial subject, but you have to do more than merely be there. I mean, I was very curious about, there was that statement in one of the Irish courts where they said, just mere presence and observation will count. Actually, it doesn't. You can tag along and watch somebody commit a crime and film it and make notes. And so long as you don't actually participate in that crime in any way, then, that's not an offence. I mean, what quite often happens with joint enterprises, people will argue and say, well, it was my friend who was actually doing the mugging, I just stood behind him. But if there's a big gang of you stood behind somebody, well, they'll say, well, in that case, you were sort of adding to the intimidating atmosphere, and therefore that's enough for joint enterprise. But I haven't seen any cases of anybody, because the sentencing remarks are being published, and people are taking part in active disorder. I mean, the fact that they might do something innocuous, man sort of sentenced for pushing over wheelie bin or for saying hurty words, yes, and also throwing bricks and petrol bombs and breaking windows. I mean,
Yeah,
it's
and even then, if they are like that one lady that was filmed with the wheelie bin, that was, as you say, Al, that was one thing among many of the others. But if all of that is going on, I still don't understand. I mean, I understand what people are upset about, but I don't understand how they think that attacking the police in this scenario is going to help anything. I just don't get that. I mean, why would something like that, one example of pushing the wheelie bin towards the line of police that are trying to keep order, what is that to achieve? I just don't get that. But and then there's another question that pops up, which I think conveniently we can deal with here, is a lot of people say, well, what if I'm just filming it and say I'm a reporter and therefore they have to leave me alone? Well, I think there's an analysis there that can be had, which is, well, are you really a reporter? I mean, first of all, from the starting point of anyone can film anything generally, and that by itself is not, taking part in the unrest and the violence. But if you are in the middle of the crowd and pushing people around whilst you're filming, that might be slightly different. But then again, if you were genuinely a reporter, you will have had a track history of, selling film, filming it to send to the papers, or all that sort of stuff. Or you and me here, Al, even doing these videos. I mean, I'm not a journalist. I don't think of myself as a journalist, but we talk about the news, Al. So, I mean, where do you define it? I mean, even when I was emailing BBC press office for TV licensing, and I said, well, can you tell me what a TV company is? And they said, well, no, not really. And so even if they can't tell us a list of TV companies, how is there a list of journalists? Well, so where do you draw the line? So if you are just standing there filming something, and then there was the whole, I think you did a video on the journalism, where can someone be forced to hand over their footage? Well, yes, with a huge caveat, because only yes if it goes through the court process to get an order, which is not. It's not a case of walk in and you get it. It's not a given.
No,
they can't
not at all.
just force you to hand it over.
No, and one thing is, the courts have very much moved to the position that they do not see a distinction between, quotes, accredited journalists and citizen journalists. And it's worth pointing out that a lot of sort of, quotes, proper newspaper journalists are not accredited. A lot of the old school ones who started, work their way up from the local newspapers. I mean, I know journalists because, to be accredited, you just do a course and pay some money. And they're basically, I'm not handing over a couple of grand just to say I'm an accredited journalist. I've been doing this for 30 years. But what's very interesting is, in the case where they're trying to get the journalist to hand over the footage, they've accepted that, yes, he was just there as a journalist, because different rules can apply, if you are caught up in the criminality yourself and just recording it for whatever reason, then you lose the journalistic protection. But in this case, the police haven't even tried to argue that it's not a journalist. They've accepted that he was just there filming it. And now they're going for the application, which is, we need this material because it would help in the prevention or detection of serious crime, because they can't just ask willy-nilly. They have to show a good reason for asking it. And the courts have always proved to be very reluctant to interfere with journalistic protection. I mean, I gave the example of that case where it was under the prosecution under the Official Secrets Act, and the material they were trying to recover were allegedly stolen top secret material. But the court said, well, once that has been handed to the journalist, it becomes journalistic material. It doesn't matter what its source is. So, yeah, you can chase after the person who disclosed it because they are a public official and they breached the Official Secrets Act. But once the journalist gets it, and also the journalist doesn't have to reveal their source. And they were saying, well, tell us who gave you this material. And they're going, well, no, that's my source. And the mere fact that the source may be involved in the criminality, again, it doesn't necessarily get you over that threshold. So,
and that has to be an important thing here, because I listened to the BBC interview with, I think it was that journalist in question, where he said, well, no, he would never be trusted again if he were to hand his material over to the police. And I think the interviewer said, well, what if the police were to pay you for it, just like anyone else would pay you for it? And he said, well, no, because then it would be viewed that I work for the police. And then the interviewer said, well, what if it was a really big number? Like, well, it doesn't matter what the number is. Do you put a price on your credibility and your trustworthiness if someone thinks that it would be corrupt, wouldn't it? It would be just like saying, well, to a barrister, which of course they wouldn't do. I certainly hope not anyway. But if someone to say, well, get them to throw a case and not, do a bad job, or it just wouldn't work. It just wouldn't happen. And if it did happen, that'd be disbarred very quickly. You've got to have
I'm sorry, carry on, yes.
No, carry on.
No, the courts have said they recognise the importance of a free and independent press. And as they say, the press isn't just a watchdog. Sometimes it has to be a bloodhound. It has to go out there and properly investigate. I mean, the risk, of course, is that, journalists get killed in war zones all the time. And that is because they effectively embed themselves with one side or the other. And, that's the flip side. It's like we recognise that journalists take enormous risks to report on conflicts and things like that. So they are given this huge amount of protection because, the public policy is, well, yes, this might help us solve one particular crime. But then, as you say, and as the journalist said, it would undermine everything else because who else, nobody would ever trust this person again or any journalist. And, a lot of the time, big stories are only broken because whistleblowers feel confident talking to journalists, knowing that, their identity will not be revealed. I mean, lots of newspapers, The Guardian have it. The Guardian have a very sophisticated system that you can report things to them if you're a whistleblower, and it's all hyper encrypted and it's all super, super safe and all, that's the general idea anyway. And the courts recognise this. But, to get back to the point, I mean, these things are being documented. I don't think a lot of the stories are being reported very accurately. Sometimes that's in the first place because, newspapers and TV, they have limited amounts of time or space to get a message across, and they do tend to take shortcuts. And a lot of the time, they don't give all the nuance or the background. But then things get repeated on social media, and people cherry pick the highlights. So it's very easy to say, man sent to prison for 3 years after drinking bottle of water. And, that's technically true that, this thing happened after that thing. But then they forget that, drinking bottle of water that was looted from shop during middle of Riot, to go back to the, 2011 riots where,
there was a fantastic example of that from a major news outlet just recently about a teacher, and said, she was sacked for saying something to the children, which people then inferred to be racist. That was the headline, but gave that impression that she was sacked for that reason. But actually, when you look into even the article, but then when you look further into the tribunal's ruling, which I did before I formed judgments on these things, the tribunal judge said, well, saying that wasn't enough to sack her. That was just immaterial, really. I mean, it wasn't immaterial. It was, it was something she probably shouldn't have said, etc. But it was immaterial in the respect of sacking her from the position. So the headline doesn't give you the impression that actually she assaulted one of the children, and that's what she was sacked for, not what it appeared from the headline. So that's what really frustrates me with the headlines, because that's all. Sometimes that's all people read, and I know you should read the headline and the body. And again, you've discussed that at great length with defamation. But just while we're going on, make sure, if you're wondering where ours come from, it's come from Art of Law over here. So make sure you go and subscribe over here as well. Will be linked in the description below. But let's talk about the sentencing guidelines, because we've got various offences here. And the big change was when judges were, seen to be encouraging the prosecutors to actually charge for the offence that they believe they should have been charged with. And this is a bit of a bone of contention, because very often, in my limited experience in criminal practice, things are charged much lower than they perhaps could have been, and that's usually to secure a conviction. But also the possible sentence is much lower as well. So, violent disorder versus riot, obviously, are very different. And you wanted to chat about these as well, Al?
Yeah, I mean, it's interesting that a lot of people have been charged with violent disorder, which has a maximum sentence of 5 years, whereas riot, it's 10 years. Now, I know some people have been cynical and said, yes, because if it's a riot, anybody who has any property damaged can claim compensation from the police, but it has to be an actual, quote, riot. And a lot of people have been saying, that's why they're only doing this. I mean, I think the thing is with violent disorder, the only difference between riot and violent disorder really is the number of people taking part. For it to be a riot, it has to be at least 12 people. But when we're looking at these sentences, and like I say, what's been very helpful is, first of all, they've been publishing the sentencing remarks, what the judge says. But also, more importantly, they've been televising a lot of the sentencing. And I think that's a relatively recent innovation, is showing televised sentencing. But what I think it is useful, because if people want to sit through, first of all, they see that, it takes 20 minutes sometimes to sentence somebody, because the judge will go through and explain exactly their reasoning for the sentence and how they have applied the sentencing guidelines and what factors they've taken into account, what factors they've considered irrelevant, what they've thought were aggravating factors, what they thought were mitigating factors. And I think, I'm a big fan of transparency. I think the more people can see about the criminal justice system, first of all, I think it will increase confidence in the system, but also it will also highlight where there are genuine problems. There's a very interesting exercise that people repeat a lot, which is where, and you can actually do this on the Sentencing Council website. They've got like a "you are the judge" thing where you get to sentence people. But they sort of, say, here's a set of facts of a real case. Here's what actually happened. Here's the agreed facts. And they ask, what sentence do you think the judge gave? And what sentence would you have given? And what's very interesting is it's almost universal, but in both cases, people go less than what the judge said. So they underestimate what the judge actually imposed as a sentence, but when they impose their own sentence, that's usually less than what the judge sentenced as well. So when people say, the judiciary is soft, actually the public perception seems to be that judges sentence a lot more leniently than they actually do in practice. And usually when, don't get me wrong, sometimes judges do sentence in a way that even the lawyers go, how did they come to that conclusion? But a lot of the time, when you see a bizarre what seems at first glance to be a bizarre sentence, when you actually look at the facts of it, it's like, right, they never said that in the newspaper. Now it makes sense. It might be that they're sentencing for an offence. I mean, there was one recently where I could see at first glance why people were up in arms about something. But it turned out the person had actually committed the offence when they themselves were 14. It was 10 years ago. And what they'd actually been convicted of was failing. They were under a reporting condition because they were on the register. This was, and it was like 10 years ago. Now, I'm not saying, obviously, it's still serious, a breach of your reporting conditions on the register. And that's the one where the judge said you would have gone to prison, but for the fact that, the prisons are full at the moment. I mean, that is that's a genuine, legitimate concern. A lot of my, I've been speaking to my judge friends, and they have been told that if they are thinking of imposing a custodial sentence, could they list the sentencing hearing in a couple of months' time, by which time early dawn should have kicked in and there will be the spaces available. So, people are being, and usually actually people are being, people by definition are out on bail pending sentence. So when people say, people are being pressured by the threat of being held on remand, the courts, politicians aren't supposed to tell judges what to do, but they can drop hints. I mean, the judges could turn around and say, no, we're just sentencing straight away. It's your problem to fund the prison service.
Yeah,
but,
I was going to say that actually all of that explanation there runs contrary to the common belief that people are being pressured into pleading guilty, else they'll be remanded into custody for a year or whatever, because if there isn't the space and the courts are genuinely trying to put people off coming into court, if they know that there's a likelihood they'll be sentenced to a custodial term, then that runs counter to that argument anyway. And again, as you say, Al, with when you read the sentencing remarks, which is why I always say, if I see a headline that, out of interest or for whatever reason I do read, then I'll read the article, and then I think, well, there is more to this. And then so sometimes I'll go away and I actually read the judgment or whatever it is, and then you get so much more detail. And so there's been countless stories over the last year or two that have been so sparsely reported and so much detail left out that when you actually read these judgments, which are invariably 30, 40, 50 pages long, you get all of the detail of usually exactly what happened, which you'll never get an understanding of. So, I mean, as an example that springs to mind, without using YouTube triggery algorithm words, but when people are accused of doing something to somebody else, but it transpires actually it wasn't without their permission or consent or whatever. Actually, they were in a relationship for several years, and that they just thought it was okay because they were in a relationship. But the way it's reported, as you can probably guess, is quite the reverse. It makes it sound sort of dark and really aggressive, whereas when you actually read the case, it was nothing of the sort. Doesn't make it right, because we have laws against certain things for a very good reason. But when you read the facts of it, it's not how it's portrayed. And I've been guilty of reading a headline before now and thinking, wow, that's really bad. But then I have to stop myself and think, well, take my own guidance and go away and read it if I'm upset about it, because it will explain it to you.
Well, as we've said, I've said, because I've worked in the media, and I'll do this. I'll ask people to do this themselves. Think of occasions where you have had first-hand knowledge of a story that ends up in the press. How accurately was it reported? And I think most people say, well, actually, yeah, it wasn't quite. I know what actually happened, and what was in the press wasn't quite right. Well, do you think they're getting every other story right? That is that is the filter you have to apply. Is don't get me wrong, the press we need the press to report on things, but perhaps exercise some critical judgment and maybe check. If you do want to know more about it, then maybe do a little bit of research yourself, because I guarantee that if you have personal knowledge of a story that's in the press, you'll be saying, well, they got that wrong. The other thing to remember about all these sentences, because I want to address the questions. And like I say, the two things are, people are being pressurized by being threatened with loss of bail. And like I say, I've seen no reports from that. And trust me, lefty lawyers would be kicking up a stink if that was actually happening. And the other thing is, they're saying, oh, well, people are being told they'll get a non-custodial if they plead, and then they're being stitched up. We now officially have judicial indications of sentence. That always used to be frowned upon. Officially, it never happened, because we've got this idea that we don't engage in sordid things like plea bargaining. And if people didn't do it, they plead not guilty, and they should only plead guilty if they did it. Now, what you could always do was pop off and have a little word with the judge in his room or her room and say, look, judge, hypothetically, if my chap was to plead, what would they be looking at? And you would actually get off-the-cuff indications. Now that has been formalised, and you can actually request and say, I would like an indication. Now, the judge can say, well, I can't give you one now because I need to hear more about the facts of the case. But more often than not, they will say, right, well, let's just say that if this were a contested trial, and your client was to be convicted, because they eliminate we're putting pressure on people. If this was to be a contested trial and it was pleaded, and based on the facts that I know, unless there was any particular mitigation or aggravation, I think the sentence would be X. And then you can do the calculation yourself and go, okay, well, if they plead, they get the third off discount, and I've got a little bit of mitigation here. So people can actually, the people who are pleading to these will have had a very good idea as to what they were looking at. Their lawyers will have said, you are likely to get 32 months or 28 months or whatever. Because first of all, the sentencing guidelines, as I've mentioned before, my judge friend who called it sentencing by flipping spreadsheet. He didn't actually say flipping, obviously. And there is a lot of truth to that. Judges have a lot less discretion now than they might have done in the old days. But, that is deliberate. The idea is it should be consistent. It doesn't matter whether you're sentenced at one end of the country or the other, or by a soft judge or a grumpy judge. You should be looking at about the same sentence. And I have to say, I haven't seen any sentences that depart radically from the sentencing guidelines. And if they do, there are two options. If people think the sentence is high, the test is manifestly excessive. You can appeal on that. Now, like that manifestly does a lot of heavy lifting. The mere fact that the sentence is a bit higher than other judges might have done won't get you an appeal. And don't forget, you can appeal against sentence even if you've pleaded guilty. You can say, I pleaded guilty. Here's the sentence I got. I think it's manifestly excessive, and you can appeal that. Also, if the sentence is, quote, unduly lenient, it can go the other way. The Attorney General is allowed to appeal the sentence. But again, the test is unduly lenient, not just it's a bit lenient or other judges might have sentenced higher. It has to be, so in both cases to appeal, the sentence has to be extremely wrong, not just slightly outside the guidelines. And the Attorney General, they don't run these cases lightly. I mean, I remember a previous Attorney General bringing Attorney General's reference that was purely for political reasons because the judge had got it absolutely spot on. And the Court of Appeal were very dismissive of that. And, they dropped big hints that, this is a procedure that you do as your role as the Minister of Justice, not just to make headlines and look like you're trying to do something.
And so if we take an example here, Al, we've got, and this is under the violent disorder, not riots, but this is just violent disorder. So if we take here, and just for those that are not familiar from our previous videos, there's broadly, and this is not true for every single offence, but for most offences, you've got culpability and harm. How involved were you and how responsible were you for what happened? And then what harm did it cause to anyone or anything else? And so these categories, so you'll get, a category 1A or, 2B, whatever, and then you come down here, and this is what Al's talking about with the spreadsheets from the comment from the judge, and it falls in here somewhere where the judge decides where it starts, and then you come to all the mitigating factors or aggravating factors, what made it worse, what made it what goes in favour of the defendant, etc. And then it goes up or down based on all of that, very broadly. So let's take an example. Let's say we've got someone who's involved in these riots, and let's say they were just throwing something that didn't actually cause serious harm or whatever. They were just throwing something. But then a lot of these are going to fall right in the middle because it isn't just the threat of violence. They're actually doing something. And yet it isn't as serious as using one of these things up here, which I won't say on YouTube. But a lot of these are going to fall right in the middle. So they participated in an event involving serious acts or widespread or large scale, which of course all of this was. So a lot of them are going to fall right in the middle here. And then when we go down to the categories, multiple or extreme factors that appear in category 2 or at the bottom end, only threats and lower level, so nothing really to speak of other than the threats of the violence or low level. So again, a lot of them are going to fall in the middle here. So it's going to result in serious physical injury or serious disruption, etc., and all these sort of things. So then when you come down to here, you'll see that they're actually quite harsh, these sentences, because by the nature of the offence, it's a serious offence and it's to be looked at seriously, it's to be dealt with seriously. So this has been around for a long time. It's not like they've just suddenly decided these offenders are going to prison for years out of the blue at the drop of a hat. This has been around for a long time. So when people are saying that the judges are, quote unquote, siding with the government and sentencing harshly because they're doing the government's bidding, etc., that's not really true, because all the judges are doing is sentencing for those that have either pleaded guilty or eventually will be found guilty of what they've been accused of, and sentencing according to the guidelines. And so these guidelines, you can see, even if we go right to the bottom at a category 3C, the range still up to a year in prison. And so all of the rest, you are looking at serious custodial terms. And so that's why people are being sentenced quite harshly. It's not because judges are suddenly decided to be really harsh. It's because they are genuinely, those are the sentences. And then when you look at Riot as well, the maximum goes up to 10 years. And then when we come down to here, there's two categories. It's A and B, and 1 and 2. And so, right down at the bottom end, you're looking at 3 to 6 years. So these are very serious things.
Yeah, I mean, people say, when people are saying these people are being overcharged, I think there's actually a lot of undercharging, because there's a lot of cases here where people could have been accused, charged with riot, and they've offered them violent disorder. I mean, that is sometimes something that happens where, on the indictment they will put, riot or alternatively violent disorder, and it's like, well, if you plead to one, we'll drop the other. I mean, that does happen. The CPS are discouraged from doing that, though, because they recognise there might be a pressure. And this is very common in American cases, where they will absolutely ridiculously overload an indictment with like 1 million different offences on it. And then, they have an official plea bargaining system, which we don't have. Over here, it is considered to be very, very bad form to overload an indictment and to put on. And judges will actually criticise people of this. They will actually say, why have you put that on as an alternative offence? Because on the evidence, it's either the more serious offence or they're innocent. There's no halfway house here. And judges will say, take that off the indictment. I'm not having that. But I think actually that there has been a bit of undercharging, because a lot of these probably could have been charged as riot, should have been charged as violent disorder or affray. And similarly,
that's
with
where the judge's comments came in, isn't it? When the judge was saying, a lot of these things should have been charged as riot, because there's a reluctance, it seems, to label things as a riot. But you only need 12 people. I mean, 12 is a lot of people to be involved in something, but you only need 12 people. And when you've got a crowd of 30, 40, 50 people, it's quite clearly a riot.
Oh, it's like with that counsellor, the counsellor who, suggested that people take certain action. And he has been charged with, I mean, like I said, we don't call it incitement anymore. It's the Serious Crimes Act 2007. But effectively, he's been charged with inciting violent disorder. Now, on those facts, he was actually inciting something more seriously. Now, I'm not saying whether he actually did incite or not, and he's got all his Article 10 stuff, and there'll be lots of defences as to whether it was a real threat of imminent harm and whether it was real incitement, etc., etc. But on that case, on the facts as the Crown seem to be alleging them, then that's not what he was suggesting. Well, yes, it would amount to violent disorder, but it would also amount to a more serious offence if proven. So again, I think that's an example of undercharging.
If purely based on the video, and if everything that was alleged from that video were true, it's much more serious than that.
Yeah, I mean, like I say, justice must take its course, and he must be presumed to be innocent. And there's lots he can probably say about that, and there will be arguments, and it'll be interesting to see how the court deals with this. But yeah, I mean, it's interesting that people are saying that they're really throwing the book and they exercising the full force of the law. I'm not convinced that's actually right. I think they're offering people some very sweet deals here. And also there will be this, one eye on the fact that the prisoner state just cannot cope. It can't cope with the numbers we've got already. And it certainly can't cope with another 1,000 people suddenly, being dropped into the system.
Yeah, so there we are. I think that's a nice rounded discussion there. And so hopefully if you've stuck with us through all of that, well done, first of all. But hopefully if you have, you can probably understand now that it is very much more nuanced. There's a lot more to it. There's a lot more explanation to it. And so if you've heard all that and then think, are these people really being pressured into pleading guilty? Probably not, because they're probably advised properly that what they did amounted to these offences. And as I say, I still don't understand why. I understand the frustration. I understand what they're frustrated about, and that the conversation needs to happen. But I don't understand how it could be understood that all of these actions can assist any of that. I don't get that. But there's a lot of things I get frustrated about. I don't go around smashing things up. And I would like to think that the vast majority of people would agree that that's just not a good way of doing things. But hopefully if you've heard all of that, I think that's a nice rounded discussion with some real experience there. We thank Al for your experience here. Do make sure you go and check out Art of Law and it will be linked in the description below. Let's get Al through 30,000. You're well on your way to 100,000 now, Al.
Yeah, well, as you know, I mean, I just enjoy doing the videos. Don't get me wrong, I am exceptionally grateful when people do subscribe. I really appreciate it. And like I said, people have been doing memberships now, which is, look, I just enjoy walking and rambling. So I do this anyway. So, you're under no obligation. You have to sit through the adverts. That's enough as far as I'm concerned. But I do very much appreciate when you do subscribe. So thank you.
Fantastic. Well, have a great Sunday, everybody, if you're watching today. And thanks for watching. Make sure you subscribe. And don't forget we're on Secrets. So make sure you subscribe here as well. But that's been great, Al. Thanks for your time. And let's do this again.
Definitely. Thank you.
Take care, all.